case number 659324, State of Ohio versus Jared Bell. Defendant is appearing by Zoom. Mr. Bell, can you hear the court?
I can, yes, Your Honor.
Very good. Counsel for Mr. Bell is in the courtroom. Ian Friedman and Madeline Grant, present from the state. Kevin Brigman also in the courtroom. My understanding, there's been a plea agreement reached where the defendant will plead guilty to count 1, attempted endangering children, a felony of the 4th degree. He will plead guilty to count 2, disseminating matter harmful to juveniles, misdemeanor of the 1st degree. Correct statement, counsel?
That is correct, Your Honor.
Mr. Bell, how old are you?
Currently 34.
How far did you go in school?
GED.
Are you presently under the influence of drugs, alcohol, or medication?
No, sir. No, Your Honor.
Are you undergoing psychiatric treatment?
I mean, I've seen a psychologist. I don't know if that's psychiatric treatment.
Okay.
I wouldn't have answered that, sorry.
Okay. You understand what we're doing here this afternoon, is that correct?
I do, Your Honor.
Very good. Felony of the 4th degree, attempted endangering children, carries anywhere from 6 to 18 months in prison in monthly increments and/or a fine of up to $5,000. Prison time is not mandatory. However, if you go to prison upon your release, you could be subjected to a discretionary period of 3 years post-release control. Post-release control could involve restrictions on your activities. If you were to violate those restrictions, you can be returned to prison up to a maximum of 1/2 of your original sentence. A misdemeanor of the 1st degree carries up to 6 months in county jail and/or a fine of up to $1,000. Do you understand the potential penalties?
I do, Your Honor, yes.
Do you understand if you plead guilty, that is an admission by you that you did these crimes?
Yes, Your Honor.
Even though your lawyer may have discussed your rights at trial, it's my duty to explain them to you in open court. First, you would have a right to a trial by a jury or by a judge without a jury, whichever you prefer. You'd have the right to be represented by a lawyer. If you could not afford one, the court would appoint one to represent you at no cost. At trial, the prosecutor would have to produce its witnesses in open court, and you or your attorney would have the right to cross-examine those witnesses. You could issue subpoenas to compel witnesses to come into court to testify on your own behalf. You could testify if you wish, but you could not be compelled to testify against yourself, and the prosecutor cannot comment on your failure to testify. You'd be presumed innocent until the prosecutor proved your guilt by evidence beyond a reasonable doubt. Do you understand those rights?
Yes, Your Honor.
Have any threats or promises been made to you to induce this plea?
No, Your Honor.
Are you satisfied with your lawyers?
Yes, Your Honor.
Are you presently on probation, parole, or post-release control?
No, Your Honor.
Having said that, how do you plead to count 1, attempted endangering children, felony of the 4th degree?
Guilty.
How do you plead to count 2, disseminating matter harmful to juveniles, 1st degree misdemeanor?
Guilty.
Let the record reflect defendant has pled guilty. The court accepts that plea. Finding was made knowingly, voluntarily, and intelligently.